Very good evening. You're watching the latest edition of the Urban Debate with me, Afrida Rahman Ali. Bail is the rule, jail is the exception. The top court has once again reiterated this. In fact, the top court of the country, as well as many high courts, have over and over again underlined this. And this time, the Supreme Court has added that India is not a police state. Therefore, it is important to now consider having a bail law mandate which will facilitate easier bail. Now, liberty as embedded in the law has to be preserved and protected, observed the Supreme Court, while directing the centre to consider framing new legislation on bail to streamline the release of accused in criminal cases, noting that the Code of Criminal Procedure as it exists today is just a continuation of the pre-independence era with only a few modifications. It also noted that jails in the country are flooded with under-trial prisoners. Remember, 2/3 of the inmates in our country are under trials, and the majority may not even be required to be arrested, the top court felt, despite registration of a cognizable offence. The top court observed, in a democracy, there can never be an impression that it is a police state, because it is in direct contravention with the concept of democracy. The court also came up with a few guidelines. It said that these should be considered separate bail law. Bail law should streamline the grant of bails. The state and centre must comply with the Supreme Court directions. The high courts to find out under trials who aren't able to get bail, and the bail pleas must be disposed of in 2 weeks' time. Anticipatory bail pleas must also be disposed of in 6 weeks. States and union territories and high courts to file compliance reports in 4 months. So Mirna has been discussing this issue and has highlighted on several occasions in the past as well how bail was denied to victims even when it was due to them. And the top court of the country has now come up with this suggestion with very strongly worded observations. Tonight, I would like to ask the legal eagles on our panel, is it absolutely necessary now that we have a separate act to streamline the grant of bail, because repeated reminders are not helping? What are the challenges? Can the executive take this responsibility? To answer these questions, I have with me, joining us this evening, Dushyant Dave, senior advocate and former president of the Supreme Court Bar Association, Sanjay Hegde, senior advocate of the Supreme Court, and Pinky Anand, former ASG and senior advocate. Thank you so much for joining us here on the Urban Debate. This is going to be a very interesting, very enlightening conversation, no doubt about that. And I want the legal luminaries who are here in the panel tonight with us to explain to our viewers the importance of the observations. Mr. Dave, I'll begin with you. At one level, it seems the judiciary has put the onus on the executive, or the legislature rather, for a bail law. But from what I understand, there are already previous orders, whether we talk about the 2014 Arnesh Kumar judgment or the 2018 Delhi High Court order. The problem is compliance, isn't it? What is the guarantee that with a new law which will facilitate or streamline bail, there will be greater compliance?
I think first and foremost, we should look at this order as an expression of anguish, expression of frustration on the part of the highest court of the country. And it is also an expression for protecting the fundamental rights of the citizens, because the judges feel, as custodian of their fundamental rights, that the fundamental rights appear to be violated routinely by the police and perhaps by the subordinate judiciary. So I think this order is perhaps yet another reminder. As you very rightly point out, it has been said so again and again, but the state, the executive, the police particularly, and the subordinate judiciary don't seem to be following what the Supreme Court has been saying for a long time and what the statute says. In fact, what judges have said today is what is expressly provided in section 41 and 41A and 42. So I think the judges are trying to now once again remind the police and across the country and the judges that please, for God's sake, follow the law. Don't take away the civil liberties of citizens in a routine manner. Ensure that law is complied with. And only when it is strictly complied with, when you are satisfied it is complied with, then justify the arrest. Otherwise, don't justify the arrest. release people straight away. So that seems to be, I think it's an extremely important, I would say, development. And I'm really happy that Supreme Court is realizing that the situation on the ground is rather sad, rather bad, and therefore, highest court needs to step in. So I think it's a very good, I would say, move on the part of the Supreme Court, and let us hope that once and for all, finally, this controversy is settled.
Yes, Sanjay Hegde, the failure of the investigating agencies is often pointed out as the reason why there are prolonged, period of jail for the under trials, their failure to furnish evidence, failure to conclude trial. How will a bail law help matters?
Bail law will help matters if the policemen and the courts below just finally get the message that you cannot routinely arrest citizens and dump them away and say that, okay, get bail from the crowded courts in God's good time. That is the heart of the entire problem in India. We also have a problem as a society. Everything and anything ends up in a criminal matter. You see any marriage going sour. No sooner that happens that either side then reaches the police stations then to become forums where there is an exchange of money and things. If they get sorted out at that stage, well and good. Otherwise, one party or the other wants the other arrested, saying that that person cheated, that person took away jewelry, that person did this, that, and the other. If we can't handle our marriages, we want our spouses in jail. As a society, also, we have to realize that the normal rule, even in a criminal matter, is that till a man or woman is proven guilty according to the law, even such a person deserves to be out and free. It's only after you finish the entire process of proving the guilt beyond reasonable doubt in accordance with the Evidence Act and the Criminal Procedure Code that you can finally send a person behind bars. We always tend to put the cart before the horse, and then you get into a culture where either the policeman wants to fiddle around with the investigation and say, look, no case is made out, therefore set them free. Or the courts themselves think that when they admit somebody to bail, it is actually a privilege. We haven't yet moved to a state of mind where bail is seen as a right. And unless there is something absolutely threatening about the accused, there is no reason why that person should not be admitted to bail.
Yes.
So I do hope that this judgment becomes the starting point for a whole new discussion. And it reminds both the police as well as the trial courts, as Dushyant Bhai has correctly said, to admit people to bail in almost every case, except where there are very strong reasons which justify the arrest.
But isn't that the problem, Mr. Hegde? The moment you say unless there are reasons that the court can satisfy itself, there lies the grey area. Pinky, Anand, I would like to bring you in on this. All these points that Mr. Hegde mentioned, actually the court actually has also mentioned these things. Huge pendency of cases, unfair arrest, overcrowded jails, the fact that ultimate acquittal, with continued custody becomes grave injustice. All of this were pointed out. But again, the issue is also about equal application of the law, isn't it? It doesn't help just to have the law, because we have seen, and correct me if I'm wrong, for one journalist, it becomes easier to get bail. For another, Mohammed Zubair, it becomes difficult to get bail. So isn't it also about, application, the equal application of the law, Pinky, Anand?
You're right. There's no question that, there should not be equal application of law. But do you have equal situations? That has to be also seen. So the question is, when anybody says, and Dushyant was saying, that let bail be a matter of right literally and be granted to all excepting, save and except where circumstances are proved otherwise, I'm afraid that can hardly be the case. I mean, while I'm in complete agreement with what the Supreme Court has said, including inter alia following all the procedures which are prescribed under 41, 41A of the CRPC, which in fact has been highlighted, as you rightly said at the beginning, from Agnesh Kumar Gupta. But the whole aspect of bail is we have provisions which are heinous in nature. We have offences which are heinous in nature. If you commit those offences and, for example, you interfere with investigation and, for example, you will abscond, whereas maybe somebody else may not abscond, and in order to have a fair investigation process, these are the bottom lines on broadly why bail should or should not be granted. That substantive law has not undergone any change or any command by the Supreme Court in any of the judgments. What the Supreme Court ultimately holds, and rightly so, is a fact. And I'm not even sure about this new bail law that must be set out. Each of these provisions is there. What happens is non-compliance. So coming back, what is required for granting a bail? For a bail, you need to justify, as I said, that in fact you are prima facie innocent of the offence committed. Prima facie, the offence which you are said to have committed is not heinous in nature or grievous to society. Prima facie, you're not likely to, not prima facie, in fact, you're not likely to abscond. Prima facie, you will not interfere in any of the investigation processes or with the witnesses or in any manner hamper the trial of the case. If you fulfill these ingredients, the general rule is, and starts from Gurbakh Singh Sibia, which was established in 1978, to say that bail will be granted. But in non-bailable offences, the idea is why have they been made non-bailable? Because they are heinous offences and committed against society. So I'm afraid you cannot have a rule of granting bail as such. You cannot have, in principle, you have equal application of law. But in principle, you will never have, and in practice also, you will never have equal offences. You will not have people who are going to abscond. One person may abscond, the other may not abscond. So therefore, you have to take every viewpoint into consideration. There has to be the discretion and the reasoning of the court which is exercised. What the Supreme Court has done, and repeating itself over a nation, is to say, don't arrest in the first instance. Please see what is required. Give a notice under Section 41. When there is non-compliance of notice under 41A, then only consider arresting. You follow the entire procedure. There must be a reason why you would arrest. Simply because it's a non-bailable offence or a case has been made out, you will not go and arrest a person. So these are the principles that the Supreme Court has been highlighting, and rightly so, considering in particular, I am not even going to individual cases. The number of under trials, I think, is a principle to rot in jail, as one sees from the
Yes,
judgment,
but Ms. Anand, police has become a tool in the hands of the ruling party, isn't it? So if yes, because arrests are made often to settle scores. They're used as political muscle flexing. Am I wrong?
Well, I think it's very unfair to say political parties. In any case, why ruling party? The point here is not this. The point is the police acts excessively. You put the burden on the political party. That's not a fair assertion. It may be in some case, it may not be in some case. So I don't want to join issues into each of these reiterations. But why should it always be said that when the police acts excessively, it is at the instance of a political party? I'm afraid that requires some thought on this process. And it varies, I'm sure, from case-to-case basis.
Mr. Dave, my concern is, will a bail law...
Afrida,
go ahead.
One thing. What I think is one of the most important parts that the Supreme Court has laid down today, incidentally, is this. The bail petition should be decided within 2 weeks or maximum 6 weeks if there's an intervening application. I think that is one of the strongest points which comes across, which is not there in the current law and which possibly requires in one way or the other to come into the current law through the executive or otherwise, because that is one of the main problems. One is that you are arrested. All right, there's a justification for being arrested, but you require the rule of law. So it must be considered within a period of time which requires you to be free in case you are entitled to be free, rather than waiting for years at times where matters have taken. That message must go down strong and clear down the ranks.
Will it be framed as a law? That remains a question. This is again more guidelines that the Supreme Court has given out. Mr. Dave, our concern in the present circumstances is clearly that will a bail law, as proposed by the Supreme Court, help in restoring the balance in terms of how, where dissent is not crushed, where critics of the ruling party are not jailed?
No, I don't think I mean, any law is going to make a difference. However, strong a law you may bring, however many judgments Supreme Court may give, the ground reality is that the police functions in an absolutely, I think without any respect for law. and at its absolute discretion. They don't care a damn for anything, either because they are ignorant or because they are influenced for a consideration, whatever that may be. It may be political, it may be, financial, it may be personal, whatever it may be. I think, we must understand one thing, that criminal law is very, very procedural. And the law at every stage seeks to safeguard the liberty of every citizen. Even when police registers the FIR, they must investigate and find out whether credible offense is made out or not. When police produces the accused before the magistrate, he is supposed to satisfy whether there is really credible, offense which can be said to have been committed by the person. So at every stage, before the man is even arrested, the police and the magistrate are required to satisfy themselves. And if at that stage they feel that no, we are not satisfied, the person must be released straight away. Now, this is what is missing today in the country entirely. In every case, in a monotonous manner, the police will go and register an FIR. They will pick up the people. They will be arrested. They will be produced before the magistrate next day. And magistrate, in a routine manner, will send either the person to jail, judicial custody, or give police remand, as the case may be. There is really no understanding of the law on the part of either the police or the magistracy. Now, Section 41 and 41A, which judges have spoken about yesterday,
yes,
really speak about this credible information to register an offense, really speak about not to arrest somebody if somebody is willing to cooperate following the notice. So the police doesn't care. There is really on the ground no rule of law, and it has nothing to do with politics. I think everybody is suffering. A poor man is suffering, a journalist is suffering, a critic is suffering. I think citizens are suffering. It is only those who are in power who are never made to suffer.
Yes, the role of the police and, the due diligence that they're required to do is sorely missing. We've reported about this in case after case. I'm going to just read out this part that the Supreme Court has observed, where it says the rate of conviction in criminal cases in India is abysmally low. It appears to us that this factor weighs on the mind of the court while deciding the bail applications in a negative sense. Courts tend to think that the possibility of a conviction being nearer to rarity, bail applications will have to be decided strictly contrary to legal principles. Mr. Hegde, do you think that is where because you mentioned the mindset issue, do you think that this is, a very pertinent observation and that is where the course correction is required?
Of course, the court's observation is based on the court's experience, and it is the experience of all of us that they sometimes have an arbitrary rule of the thumb while deciding bail applications. Oh, what's the offense? How much does it carry? Have you spent half the time inside? Then we'll consider. Otherwise, you're hale and hearty. You're not an old person. You have no medical issues. No. At least in a case like this, where the allegation is this, I will not grant you bail. What this kind of approach does is that, there is a sort of judicial determination that if the police have investigated and filed a charge sheet, then there must be something about you. You must be guilty. Whether it can be proven or not proven in court in accordance with law, that's a different thing altogether. Till then, we do not feel that you deserve bail. There's no
but
question
the old and
of
the infirm also,
bail.
Mr. Hegde, if I may remind you, even old and infirm, look at what happened with Varavara Rao, Sudha Bharadwaj. In fact, Mr. Stan Swamy at the age of 84 died in judicial custody in July last year, isn't it? I mean, this was with regards to the Bhima Koregaon case, and if I understand it correctly, his bail remained pending.
Correct.
Bail
Absolutely.
still remains pending,
Yes.
and in UAPA matters, bail is now impossibly hard to get, particularly after the Supreme Court's judgment in the Vatali case, where they said that you must have a very high degree of satisfaction, and even if the police produces some material, you must assume that there is material to go to a trial, and unless a person is acquitted after a trial, which will happen in God's good time, then you will not grant bail. The Supreme Court in subsequent judgments seems to have tried to find a way out of this kind of a heavy-handed judgment of 3 judges. But that's exactly the point. What is a police state? A police state is a state where a policeman can make a determination that this man deserves to go in. And then there is almost nobody who can correct that determination, short of holding a full trial and finally saying that no, all this, we gave ample opportunity to the prosecution to produce material. They have still not been able to produce material, or the material is not enough, and therefore I acquit the person after he has completed almost the entirety of the maximum sentence that he or she was likely to suffer. So what is the big sense of acquitting somebody accused of murder after 13 years of incarceration?
Yes.
When normally, if there is a life imprisonment and with remission, he would be entitled to seek remission after 14 years. This kind of thinking that, we will not grant bail, or bail is something that has to be deserved, that I think requires a change of mindset. One particular reform that I would like to see is that whenever somebody is jailed or imprisoned, the investigating officer or his superior must put up a written memo saying, this is why we think that the person should be, person's custody is necessary, and that his continued custody is necessary. The policeman signing should be then responsible if at a later stage it is proven that the arrest was illegal or improper.
Sanjay, but he would have retired long ago, so nothing can be done about it.
Yes, but even if he is retired, once you ask people to put things down in writing,
the law requires.
That is a very big check in itself.
No, but are you saying there should be culpability fixed for the concerned officers if they do not follow the due process? Now, will this be binding on the police, Mr. Hegde? That's the question, isn't it? I mean, yes, Mr. Dave was already stating this, that there is no understanding of the law. Isn't that a huge gap to cover in the first place?
Vida, I must add on here. I know
Please
you
go
asked
ahead.
Sanjay,
Go ahead.
But I think it's not a question that they don't know the law. They know the law. There's very few people who don't know the law, and the police would definitely know Section 41 and 41A, which broadly covers the territory of credible information, giving a note, having a reason to arrest anybody. The question is actually of culpability. You ultimately need to come to a position where there should be culpability of police officials for failing to comply with the law. And I think when you have a position of sanction, as Sanjay was also talking a little while back, quite rightly so, when you have a position of sanction, whether retired or not retired, the position is you put people in that predicament to say you have to have a memo. When you put it in writing, it would lead to their answerability directly or indirectly, and would definitely have a more responsive situation. Plus, if you have ultimately action taken for culpability, for even a few cases of non-compliance, you will find that compliance tends to get better. That is the whole purpose of law.
That's a very important point. Okay.
You pull them up, and that is when they will actually start behaving themselves to some extent. I am not saying it's a final foolproof answer. The existence of law should be enough. But unfortunately, in most jurisdictions, including our country also, until you're compelled to follow the law, you will not necessarily follow the law. So you have to be compelled to follow the law.
The compliance part again, I'm again tempted to bring up recent cases, Mr. Dave, whether it is journalist Zubair denied bail, in the case of Aryan Khan, which got so much of media attention. Ketki Chitale's name also comes up in the conversation because of being unfairly jailed for a prolonged period. Now, depending on which side of the political divide you have your allegiance, as of now, we have seen there depends your chances of getting bail.
So there is no doubt about the fact that the judiciary is, I would say, not evenly applying the law. And I mean, I am surprised at the approach of the judges across the country. Take, for example, Aryan Khan's case. I mean, the FIR itself said that nothing was found in his possession. Now, if nothing was found in his possession, when he is first produced before the magistrate has a power under Section 167 of CRPC to straight away say that he must be released. and this investigation cannot proceed further. But he didn't say so. Now, question is High Court going to take action against that magistrate, or will he be allowed to continue in service so that he can do injustice to many hundreds of people in his career? This is where the real problem is. I remember when Chief Justice P.D. Desai was Chief Justice of the Bombay High Court, he weeded out large number of such judges, on this power under after the age of 55, where he found that the judges were grossly inefficient or were acting in extraordinarily funny manner. Now, people, we don't understand respect for individuals' liberty. We have no respect for constitutional rights of citizens. I don't think with great respect, I have an immense regard and respect for Pinky and Sanjay, but I don't think the policeman knows what constitutional rights are. He has no idea about what the Criminal Procedure Code is. Section 41A3 expressly says that if he is going to arrest, despite appearance of the accused upon notice, he must record reasons. It says so. But how many times does he do that? So, it is nothing to do. I personally feel that we need really, one message from the Supreme Court is not going to change. We really need to revamp the whole situation. We need a debate. Take, for example, this George Floyd's death in America. It led to a movement where everybody in America was appalled by the treatment that police gave to this black man. Now, we need this kind of awareness amongst people that you cannot target people in this fashion. Everybody must get justice in accordance with law. And if injustice is done, then we must speak about that openly. We must speak against our policemen, our judges who fail to follow the law. There is nothing wrong about it, because liberty is far more important than, this kind of false belief that judges cannot be criticized. So I personally feel that judiciary is greatly responsible for this state of affairs rather than the police. And I regret to say that, because I love judiciary immensely. And I must say that judiciary is not, there must be zero tolerance by judges to this kind of infraction of laws, this kind of violation of constitutional rights. That's not happening. The judges are not coming down heavily on the police and the investigating agencies. And unless they do that with a zero tolerance, then nothing is going to change.
Okay, very important points made, but I think two things are coming out very clearly. One, the issue of non-compliance of 41 and 41A dealing with arrest. Police, as Mr. Dave said, is not complying with these sections. It's already there. Therefore, how will a new law help? That is one. Second part, I believe at least two nations, UK and US, already have, bail acts, which have helped them streamline the process. So while we are questioning whether it will help, we have instances, Mr. Hegde, of such bail acts already in existence in other developed nations?
Well, you did mention a couple of them. Yes. But the provisions of the existing law are more than enough as far as bail is concerned. There are enough guidelines. What will an act do except to consolidate everything? The judges have rightly pointed out that most of these people are under trials. So more than a change in law, I do think that a change in mindset, and as Dushyant Bhai correctly said, a culture of accountability. Now, how can you hold a person accountable? And Dushyant Bhai said that by the time a court comes to that determination, the policeman concerned has retired. Any police department that has to then compensate in huge monetary terms will automatically seek to recover at least some part of that from whatever are the policeman's dues, including his pensions. Just a message that what you do today can continue to haunt you through the rest of your career and maybe even after retirement. That awareness itself among policemen would be a great step to making India much less of a police state.
Fair point. What you're saying essentially that if there is a subsequent acquittal and if it comes down to an unfair, lodging in jail for a prolonged period, then the concerned officers should be culpable and this must be considered an offence. Pinky, Anand, is that largely the point that you were making as well?
Yeah, absolutely. What we were talking about was accountability and implementation. Ultimately, the law is there. See, why do you make new laws? You make laws for two reasons. One, you make new laws because there isn't any existing provision, which there is in the present case. Secondly, you make a law to signify something. I think the significance is why we always talk about a new law. Sometimes you're not wrong. Sometimes you put a new proposition ahead of everybody. There is more attention. But the third largest issue really is culpability and accountability, not only at the stage of post-conviction or acquittal, whatever the case may be, and the culpability of the concerned officer, but possibly at an interregnum stage also. Let a senior official be entitled or empowered, rather, to look into the fact of non-compliance of Section 41 or 41A of the CRPC, and appropriate action should be taken at that stage itself, irrespective of what happens as far as an acquittal is concerned at a later stage. If a police officer is mandated to record reasons, if he's not recorded reasons, that is an abdication of his duties.
Yes, I think that there's great convergence, at least from all the three experts on these points. I would have to leave it at that. Thank you so much, Dushyant Dave, Sanjay Hegde and Pinky Anand, for joining us in this conversation.
Thank you very much. Good night.
Okay, in fact, this is a topic that we have decided to deep dive on, and this is extremely important to understand that here is a country where you have 2/3 of the jail inmates as under trials. The jails are overcrowded at the moment. There is a massive pendency of cases. The top court has time and again intervened into this issue, yet we see the trend continues. Joining me here on the program also is Mr. Colin Gonsalves, one of the well-respected lawyers of this country, who's a great legal expert, senior advocate of the Supreme Court. Thank you, Mr. Gonsalves, for joining the program. Your thoughts, first of all, Mr. Gonsalves, the fact of the matter is, we are now at a juncture where the top court believes that this country needs a separate bail law to streamline the process of granting bail. All previous guidelines issued, orders issued, have failed to ensure compliance. Are you of the opinion that a bail law could be the real answer to this problem?
That was the main point made in the judgment. I think the main point made was to reiterate an older judgment which said that if you're charged with a crime where the maximum sentence is 7 years or less, the police should not arrest. That was the main point, to bring home that point. So that was enormously good for me, because we are arguing Zubair's case in the Supreme Court now. And Zubair is charged with all sections which are 5 years and less. And yet the police went ahead in all 3 cases and arrested him. And the important part of that judgment was the part which said that policemen should be punished if they don't obey the law anymore. So that was positive for me, and it came one day before Zubair's case in the Supreme Court. But to answer your question, I really don't believe that a new law is necessary. And I really don't believe that for the simple reason that law doesn't make a change by itself. When the implementers of the law, which is the police, are thoroughly lawless and communal today. You have a police force which is so much a breaker of the law, a criminal police force, that you change the law and they really don't care. They want to obey the old law, they want to obey the new law. And the reason why they are lawless is because they come under the influence of the central government and the party in power at the center. And we have never had, since independence, a government that breaks the law and engages in hate speech at the level of the present government. So if anybody, if any judge, if any policeman dares to disobey the chief minister of the state or whoever else high up in power, you know what's going to happen to him. So the police are gone, and there's
so then, Mr. Gonsalves, how can you then shift the responsibility to the center, to the ruling government, and expect things to change? Because you are saying that there is political influence on investigating agencies, on police, owing to which this is the condition. Then why would any change be made? Why would the executive do it, knowing that it will curtail their own powers, so to speak?
I don't think you could have put it better.
To restrict
you put
dissent.
it marvelously. Absolutely marvelously.
Yes.
There's no change possible in this country. And the last hope is that the judiciary stands up and, confronts the central government and confronts the police. But I'm afraid that the judiciary has been enormously weakened during the period when this government has come to power. The government has had a lot of interference in the judiciary while being in power, and it has weakened. There's no doubt about it. There are very fine judges, no doubt about it. But the judiciary is not the judiciary it was, say, even 5, 6, 7 years ago. It's a weakened judiciary. So I am not hopeful at all. I despair for the country. This lawlessness is likely to continue. And it requires very strong people like Zubair to stand up and argue and tweet against the government in the finest traditions of the press in India, the press and the judiciary. No hope otherwise.
Okay. Well, I asked this question to my previous guests as well, that, clearly from the precedents that we have witnessed from the cases, the recent cases, and feel free to cite the cases on your own as well on where you feel the judiciary has faltered. But it's very clear to anyone, and it's not lost on anyone at all, that depending on which side of the political divide you are in, depend your chances of getting bail, at least in the journalist cases from what I have seen, whether it is Mr. Goswami or Rohit Ranjan or Mohammed Zubair. At least 3 cases of journalists that we have monitored and reported on, I could see clearly where the chances of getting bail are higher and where it is literally negligible.
Of course, if you have political power, particularly influence with the government at the center, any journalist connected to that government will get out pretty quickly.
Yes.
But if you are a person like Zubair has got now 3 cases against him. And if you read any of the FIRs, from top to bottom, and Zubair admits all his tweets, you will not find a crime in that FIR. So what are they doing? They take an innocuous FIR where he's fighting against hate speech people. People have said the most horrifying things. We will kill you, we will do this, we will do you. And their courage comes not from themselves, because I doubt it, they're very courageous people. Their courage comes from the fact that the government supports them. And their courage comes from the fact that the police will not touch them, because they've got instructions from above that these are our favorite people, don't touch them. So I don't have any hope at all, except if the rank and file of the people of India say, we've had enough. We don't want this kind of hate speech. We believe in secularism. We believe in peace. Please don't tell us that this is linked to any religious and so on. It's nothing. It's pure dadagiri. And we don't want this. We'll stand up against it. That's a tough job. People have to put their necks on the line. People have to suffer imprisonment. And people have to will be persecuted for their beliefs. But that's the period we are in India. Many times more dangerous. Many times more dangerous than the emergency ever was.
So, Advocate Colin Gonsalves, I'm going to ask this to you point blank, because this is in your words, and you have said this while arguing before the Supreme Court in the Zubair case, that the persons who engaged in hate speech are out on bail and the person who exposed them is in jail. Do you think, the justice system really is compromised to that extent? Can you spell it out for us where exactly you feel it is so?
Well, I told you, there's interference in the judiciary at all levels. Earlier, there used to be a distance between the executive and the judiciary. The executive was not supposed to talk to, judicial officers and so on, and pressurize them and influence them. But today, that gap has shrunk enormously. So what can judicial officers do if they stand up to the government, which is as powerful as this government? When they win election after election after election, obviously, lakhs and millions of people support this government. If you stand up to the judiciary, what's going to happen to you? You'll be superseded. Somebody many rungs junior today will suddenly come above you and become Chief Justice or reach the Supreme Court. Or you'll be transferred to to a court like Meghalaya or Sikkim, where there are hardly any cases and few judges. So victimization of judges. And judges have fear that after spending 10, 11, 12 years in a high court, working from morning to night, Saturday, Sunday, dedicated, doing your work honestly, they are afraid that at the fag end of their career, they'll be victimized and persecuted. They'll be left behind when their juniors are taken up. So it's a terrifying situation. And I'm glad that your channel carries these kind of programs, because the people of India must rise in revolt against this tyranny.
But Mr. Gonzalez, aren't you hopeful that the top court has come up with this? It has made certain very strong observations, talking about the overcrowded jails, talking about the unfair arrest, pointing out all the maladies that you listed, in fact. These are also observations of the top court, owing to which it says that let's make it more difficult to deny bail. Aren't you hopeful that maybe perhaps this is a step in the right direction?
It is. It is a very important, it's a very good step. It's a very important judgment. And I salute the Supreme Court for this judgment, but let me remind you, the court has some 35, 36, 37 judges, and they certainly don't think alike. And now the schisms in terms of ideological thinking and so on in the judiciary generally is quite sharp. So we applaud the good judges. We encourage them to do the work that they are doing. We benefit from these good judgments, and the people of India benefit. But for every good judgment, there's also plenty of very, very terrible judgments, very bad judgments. So it's a mixed bag. And it's important for the press to support and applaud judgments like the present judgment, like you're doing in this program.
Yes.
But equally, take a critical view for judgments of the courts, which actually go against the Constitution, human rights, and fundamental rights. That's equally important for the press to do.
You're focused on the larger malaise, but I want to draw your attention to some, smaller issues which can easily be corrected, isn't it? For instance, the court has observed that the harsh conditions of surety in bail becomes an impediment. So those kind of issues, do you think, can also ease out the process? At least you will not be in a situation where 2/3 of your inmates are under trials, most of them for crimes that do not warrant more than 7 years in prison. These little things, how do you propose, the revamp in the criminal jurisprudence to correct these issues, which can also perhaps streamline the problem?
Let me just inform you that this issue of overcrowding is perhaps 25 years old. Getting worse as time passes. So today you have 250% overcrowding in the prisons, with people sleeping body to body. Can you imagine?
Yes.
And this issue of surety and so on, making it so difficult for people to get out even after they get an order for bail, is also 20 years old. Why is it, and this is the question that you must ask and try and get an answer, why is it that what you call such a simple issue could not be solved for 20 years and more? And the answer, I'll give you one answer, is we've lost judges, the old type judges, old generation judges, who were courageous, hard-hitting, no-nonsense judges who had a vision of the world they wanted and gave such judgments that they transformed the world with those judgments. Now it's not like that. Now the vision has shrunk. The courage has gone down. And the capacity to, say to yourself as a judge, what needs to be done on overcrowding? We need to get tens of thousands of people out of the jail. Young people, first-time offenders, disabled offenders, women, etc., etc., etc. We need to get them out by a decisive judgment.
Can that happen, Mr. Gonzalez? Can we immediately do something
it can happen,
for the current inmates? For those who are lodged in jail without trial and who cannot pay the surety, what is your one-point solution for
Personal
them?
bond, the provision exists. The law exists. There's nothing wrong with the law. and everyone knows what you need to do. You can't have 250% overcrowding. Just clear the jails of the persons who are not hardened criminals.
Yes.
Why is it difficult to do? I think if you were a judge, you would pass an order immediately for clearing people who are not hardened criminals out of the jail.
Right.
But why is it?
Yes.
And that's the question, that we don't have judges of conviction and courage to do it. You're in the Supreme Court for 5 years. You're in the seat of God. You can do anything good for the people of India. You can transform India in bits and pieces. You can transform. Why are we going on in this business as usual way? Why? In 5 years, the clock is ticking. And in 4 or 5 years of your tenure, you'll be powerless and nobody will even look at you. Why, when you have power, you don't have the courage of your conviction?
I really appreciate, Mr. Gonsalves, you're imploring the judges of this country to have more courage. I think that would do all of us a lot of good. I appreciate you joining us with your valuable opinion and your informed opinion on the subject. Thank you so much, Colin Gonsalves. Let's take a short break here. News and updates continue on the other side. Stay with the Urban Debate.